Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. Now, you have been asked to come to court today for this particular case. And the case that you have in this court, it is a misdemeanor case. It is a criminal misdemeanor case. Now, criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. They could be given a fine from that. Well, actually, the fine can go all the way up to $10,000. Now, if a person is convicted of the third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Person is convicted of a second-degree felony. The range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the case that you have is a misdemeanor case, so you don't have to worry about those type of punishment. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, then the range of punishment is by fine only. You only can be given a fine, you cannot be given a jail time, and the fine cannot exceed $500. Now, the Class C misdemeanors are cases that start in the city court or the JP court. For example, a traffic ticket. Class C misdemeanor: speeding, not having your seatbelt on, not having having an expired inspection sticker. Those are Class C misdemeanors. Now, if a person is convicted in the JP court or the city court, and they appeal the case, in essence, they want a higher court to appeal the case, they get a whole new trial in this court. The range of punishment stays the same, which means that it's maximum fine of $500. That's all. You cannot be given jail time. Now, if you fail to pay the fine, or if you fail to perform community service, if your fine was converted to community service, then the judge can issue what is called a capias pro fine. A capias pro fine simply means that it's a warrant for your arrest for you to either pay the fine or to sit the fine out in jail. And if you sit the fine out in jail, for every 1 day that you spend in jail, $100 will go toward your fine and court costs. All right. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Yes,
But if things be missing, they don't give out probation.
that's next. I'm getting to that next. Now, a person may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And the other type of probation is called adjudicated probation. And the difference between the two is as follows. With unadjudicated probation, you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for what is called a non-disclosure. What a non-disclosure basically means is that your record will be sealed to the general public. So the general public cannot have access to your criminal record. Now, the operative word that I use is general public. And that simply means that the government can have access. Governmental agencies, there's a list of governmental agencies in the Texas Code of Criminal Procedure that can have access, but most of the public is general public. So most of the public cannot have access to your record if you get a non-disclosure. Now, the other type of probation is called adjudicated probation. With adjudicated probation, you do have a conviction on your record. We call that regular probation. But if there's something that is called judicial clemency, and what judicial clemency is this here? What it means is that the judge can set your conviction aside, which means you will no longer have a conviction. Now, in order to qualify for that, three things has to happen. You have to successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the court or the judge has the discretion to set your conviction aside and you will no longer have a conviction. That's called judicial clemency. However, if you get another conviction later on, we call that a subsequent conviction. Then the case that you received judicial clemency on can be resurrected, brought back up, and it can be used against you. And if you try to get a license with Child Protective Services or CPS, then they can either deny giving you a license or they can revoke or suspend your license. Now, as a defendant in a criminal case, you have rights. We're going to go over some of those rights. One of the rights that you have is a right to have an attorney. Now, the clipboard that you have in front of you, everyone who's here, okay, should have that clipboard. And I'm going to go over that paperwork with you. That first document on that clipboard should be titled Judge's Explanation. It's the long document, not the short sheet. Judge's Explanation of Rights to Defendants Without an Attorney. Now, in the document, it states, as a defendant in a criminal case, you have three options. Okay, we're going to go through it. Number one, you may hire an attorney. Number two, if you want an attorney but you cannot afford to hire an attorney, you may request or ask the court to appoint an attorney to represent you. And number three, you may represent yourself. That is, you can waive or give up your right to have an attorney represent yourself. Now, the first paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means you will be given another court date from today. Why? To give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request or you may ask that the court appoint an attorney to represent you. But you must first sign a waiver of counsel. Now, the waiver of counsel basically says that you're waiving your right to have an attorney. Well, no, not the waiver of counsel. You must first fill out a financial questionnaire. And the financial questionnaire is a 3-page document on that clipboard. And it's 3 pages. It's titled Jefferson County Affidavit of Indigence. It's a 3-page document. Okay? And the document looks like this. Yes, that's it. You would have to fill out the first page of this document if you're asking for a court-appointed attorney. And on the second page, everybody turn to the second page. If you are requesting a court-appointed attorney, you would fill out the top portion that's titled Defendant's Oath. And then the middle portion that's titled Unsworn Declaration by Defendant. And then you'll stop. Okay? And that's all you have to do. You'll stop. Now, if we turn back to that first document, judge's explanation, the very first document, the next paragraph states that you may not talk to the prosecutor unless you first sign a written waiver of your right to have an attorney. Now, that is for people who will be representing themselves. That third paragraph under number 3, past number 3. That's for individuals who will not be requesting an attorney, who will not be hiring an attorney to represent them. They'll be representing themselves. And it's simple. If you are representing yourself, you know what that means? That means you're your own lawyer. You are your own attorney. And because you are your own attorney, you will have an opportunity to talk to the prosecutor. There are 2 prosecutors, they work for the Jefferson County District Attorney's Office. You'll be able to talk to them to see if you can settle your case. Maybe have a settlement, we call that a plea bargain, to settle your case. All right? But you cannot talk to them unless you first sign the written waiver. Now, the written waiver is another document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's what it's titled. It's a 1-page document. You'd have to read and sign that. Now, the next paragraph is in block form on the first document. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status, and employment. Now, if you choose to represent yourself, you can change your mind at any time. Okay? For example, let's say you decided to represent yourself, and then you talk to the prosecutors to work out a plea bargain. And let's say you didn't like what they were offering. You can change your mind and say, well, Judge, I want to apply for a court-appointed attorney. Okay? You can change your mind at any time. That's what that paragraph means. Now, at the bottom of that document, that first document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, everybody's going to make a choice. Number one, if you would like to hire your own attorney, you will place your initials on the first line. Number 1, on the first line to the left. You're going to put your initials there, sign it, date it, and then you'll stop. That's the only document you'll have to fill out. Okay, we're talking about that first document at the bottom. Now, if you already have an attorney, then you'll place your initials on the second line to the left at the bottom, and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom. Yes. He doesn't have a pen.
Oh, I'm sorry.
He doesn't have one either. Here's one. Okay. Anybody else? Okay, so we're still at the bottom of that first document. Judge's explanation of rights. Now, if you want to hire an attorney, you place your initials on the first line to the left. If you already have an attorney, you place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, you place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you'd like to waive your right to an attorney, give up your right to have an attorney, you'd like to represent yourself, then you'll place your initials at the bottom on the fifth line to the left. Now, once you have finished initialing one of the 5 lines that I just mentioned, you will sign your name on the line that is titled defendant, and you will date it today's date, June 3rd of 2025. Okay? Okay? Now, any questions? And I'm gonna just go over this here real quick, just a brief recap. If you're hiring your own attorney, just all the documents you're gonna sign. Because you would put your initials on the first line to the left, sign it at the bottom, that's it. You don't have to worry about all these other documents that I'm getting ready to talk about. That's for people who are hiring their own attorney. If you are requesting a court-appointed attorney, you will sign this document, you'll put your initials on the third line at the bottom to the left, sign it and date it, and then you would have to fill out the first page of this document that's titled Johnson County Affidavit of Injuries. And on the second page, you would have to fill out the top portion that's titled Defendant's Oath and the middle portion that's titled Unsworn Declaration by Defendant, and then you will stop. All right. Now, if you would like to waive your right to have an attorney, represent yourself, you like to represent yourself, then on this first document, you will place your initials on the fifth line to the left, down here, and then you will sign it and date it. And then you will go to this one-page document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding the Trial. You will read this, sign it, and date it, and then you'll stop. Any questions? Okay. Now, we're going to give you time to fill out those documents. Next, I told you that you have rights as a defendant in the criminal case. We just talked about your right to have an attorney. The other right that you have, now, you're going to enter a plea in this case. What I mean by a plea is you could either enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. No contest means that you're not fighting or you will not be contesting the charges. Now, if you enter a plea of not guilty, then you have a right to have a trial. Okay? You can have what we call a jury trial. That means that when a young man is sitting, that area we call that the jury box. 6 citizens from Johnson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's being presented. They will listen to the arguments that the lawyers are making. Then they will deliberate in the jury room. They will make a decision. They can decide to either find you not guilty or guilty of your charges. Now, you also have a right to waive or give up your right to have a jury trial. If you waive or give up your right to have a jury trial, you're in a plea of not guilty. You have a right to have what we call a bench trial. A bench trial. What that means is a trial by judge only. The judge will be the judge and the jury in the case. That's called a bench trial. You don't want a trial by jury, but you want a trial, but you want the judge to be the judge and the jury in the case. And the judge will listen to all of the evidence, listen to the arguments of the attorneys. The judge will apply the facts of the law, and then the judge will decide to find you either not guilty or guilty of your charges. Now, the other way your case is going to come before the court is by way of a plea bargain. If you enter a plea of guilty or no contest, then your case comes before the judge by way of a plea bargain. There are two types. One type is called an agreed plea bargain. That simply means that you and the state of Texas have reached an agreement on your case. For example, the state of Texas has made an offer to give you, say, deferred unadjudicated probation. And you say, oh, I like that. I want to accept it. Okay, that's agreed. It comes before the judge. The judge can do one of two things. The judge can either accept or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement that you worked out with the state, then at that point, you have a right to take your plea of guilty and no contest back. For example, you say, well, judge, since you're not accepting the plea bargain agreement that I made with the state of Texas, I take my plea back. I'm not going to enter a plea of guilty for no contest. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and if you decide, you know what, in 30 days, you have a right to either file a motion for an appeal or motion for new trial. You say within 30 days, you know what, I think I've been wrong, or the court committed an error by convicting me, and I would like to appeal my case. If the judge followed the plea bargain agreement, and if you want to appeal your case, you have to get permission from the judge that followed the agreement. If the judge gives you permission to appeal your case, then your case is going to leave this court and go to the Ninth Court of Appeal, which is right above us on the 3rd floor. 4 judges there. They will review your case. And they can do one or two things. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then that's not the end, because you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you have to file what is called a pro se petition for discretionary review. What that simply means, I'll explain it to you. Pro se means that you represent yourself, you're by yourself, pro se. And you are asking the Texas Court of Criminal Appeals to review your case, to review your petition, to see if the Ninth Court of Appeals should have granted your appeal, or if this court committed an error by wrongfully convicting you. Now, they can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, I talked about you being able to work out an agreed plea bargain. Now, if you're unable to work out an agreed plea bargain with the state and you still want to go forward with your plea, we call that an unagreed plea bargain. And that's what you're saying, well, judge, I don't like what the state is offering. I want you to decide what my punishment is going to be in this case. All right? That's called an unagreed plea bargain. Now, the judge could, with the unagreed plea bargain, what the judge can do, he can assess punishment, or he or she can assess punishment anywhere within the punishment range. Okay? Now, the other right that you have, if you are entering a plea of not guilty and you have a right to have a trial, you have a right to call witnesses. I'm looking back at that chair that has the microphone in front of it. That chair is called a witness stand. And you have a right to call witnesses to testify in your case. They can testify for you or against you. If you're representing yourself, you can ask them questions. If you have an attorney, your attorney can ask them questions. We call it either direct examination or cross-examination. You also have a right to waive your right to call witnesses, which means you have a right to not call witnesses. Now, if you waive your right to call witnesses and you do not call witnesses, that does not mean that the state will not call witnesses, because the state will be calling witnesses in your case. You also have a right not to testify. We call that a Fifth Amendment right against self-incrimination. Okay? I know a lot of times we watch a lot of shows on television, Law and Order. You might see on a television show where a person is taking the witness stand, the lawyer go up and want to ask a question. The first thing they say, I take the fifth. What that means is I'm exercising, I'm invoking my Fifth Amendment right of the United States Constitution not to testify. And the state, the government, the DA's office cannot force you to testify if you exercise your Fifth Amendment right against self-incrimination. And the reason why is simple. The state has to prove that you committed the crime, right? You don't have to prove to them that you committed the crime. You don't have to do anything. That's their burden. They have to prove that if they charge you with a crime, they have to prove it. You don't have to prove nothing. Okay, that's the reason why. Now, the other thing is you can waive or give up your Fifth Amendment right, as I mentioned it, which means that if you do that, you will be taking the witness stand. Now, the other right that you have is called a right to have discovery. Discovery means that you have a right to see the evidence that the state has and will be using against you. You have a right to have access to it. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings. You have a right to have access to documents and instruments, whatever they have that they're using. They're saying this is the evidence that we have against you. You have a right to have access to it so that you can prepare for trial as well. Now, you also have a right to waive or give up your right to have discussion. Now, everybody that's here today for a case, you're here, one, because you was charged with an offense, you were arrested, you were placed in jail, you bonded out of jail, and you're out of jail either on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you didn't have to pay any money to get out of jail. You were just released under your own personal recognizance with a promise to appear today. Now, I've said that to say this. Every day that you spent in jail, that can be used as credit towards your punishment. Now, the operative word that I use is day. And for example, let's say you were arrested and placed in jail or booked in jail at 11:59 p.m. on last night. And then you booked out of jail 2 minutes later at 12:01 a.m., right? That's 2 days. It's 2 minutes, but it's 2 different days. And so you get credit for 2 days. All right? That can go towards your punishment. So, for example, if you spend 5 days in jail, state is offering you 5 days in jail, you don't have to spend no more time in jail. Why? Because you'll be given credit for the time that you've already served. Now, if they offer 7 days, you spend 5 days, you only have to spend 2 days because you already have 5. You take 5 from the 7, that leaves 2. Now, for every day that you spent in jail, you also receive $100 credit that goes towards your fine and court costs. So, if you spend 5 days in jail, that's $500 that can go towards your fine and court costs. If the state is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the time you spent in jail has already paid it off. Therefore, you will be given the fine and court costs will be taxed and retired. Now, if they offer fine and court costs of $700, that means you would have to pay $200 because you already have $500. We take the $500 from the 7 and it leaves 2. You'll be required to pay the balance, in this case, on this scenario, the $200 on the day that you dispose of your case. Now, if you cannot pay it, no problem. Because we could put you on a payment plan, which means you can pay in small monthly installments, the balance until it's paid off. Now, if you cannot pay the balance because you do not have the income or job, no problem. We can convert the fine and court costs to community service, which means that you receive $12.50 credit toward every 1 hour of community service that you perform in a nonprofit organization in our community. Now, if you owe $200, if you work 8 hours of community service in 1 day, that's $100. You work 2 days in our scenario, 2 8-hour days, that's in 2 days, that's $200, and so you'll be through with paying your fine and court cost. All right. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, it's first time here. The district attorney's office has a program where they will dismiss your case and you can get it wiped off your record. We call it expunged. The program is called pretrial diversion. Now, in order to qualify, 3 things has to happen. 1, has to be your first time getting into trouble. 2, you have to have an attorney to assist you with the application process. And that attorney can be hired or an attorney could be appointed. Doesn't make a difference. And then 3, the other thing is it cannot be an offense for unlawfully carrying a weapon or resisting arrest. If you would like to get into that program, just let us know. Or let your attorney know, and you may get in. And as I mentioned, you dismiss the case, and you could get it expunged, which means wiped off, deleted, or erased from your record. And the example I always use is like, if this is the record, your criminal record, right? Everybody can see it. Once it gets expunged, it's like this. Nothing is there, it's gone. Okay. Now, the other thing that I need to mention to you is that if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It's for veterans only. And the only thing you need to do to get in that program is be a veteran. And what they will do is, once you get in the program and complete the program, they'll dismiss the case. And once the case is dismissed, you can get a non-disclosure. What I mentioned to you earlier, where your record is sealed to the general public. All right. If you're interested in that program, just let us know, and we can direct you to the person that you need to talk to. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that is called the Community Safety Initiative. We usually call it the CSI program. It is a program that God led me to start within the first 100 days of taking office in March of 2017. That program is designed to address the issue of recidivism where people commit crimes over and over. And so with that program, we have partnerships with various agencies in our community. One of the agencies that we have in our community is Spindletop. Spindletop is our local mental health agency in the Southeast Texas region. They have the ability to address your mental health needs. And what Spindletop will do, they would have an interview. The interview can take place either in our jury room, and we have some folks in Spindletop here this morning that can interview people, or they can interview you at their facility, they can interview you by telephone, whichever is convenient for you. They also have the ability to do what is called an assessment. The assessment, well, they will determine what your mental health problem is. And they also have the ability to develop a treatment plan for either outpatient or inpatient treatment. Now, Spindletop also has another program. They have another program that is called ATAR, A-T-A-R, which is an acronym that stands for Addiction, Treatment, and Recovery. It's a drug and alcohol recovery program. And we also have a partnership with our with our local drug and alcohol council that has a program that is called OSAR, O-S-A-R, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment, develop a treatment plan for either outpatient, inpatient treatment. If you are unemployed, or maybe you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, commercialization, and entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in any one of those areas that you select, they will assist you or help you to get a job that you're trained in. If you have not graduated from high school, you do not have a GED, then they have a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. And like I say in this court, we don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they got too much to lose. And so I like to say that when you come to County Court on Law Number 2, Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to the individuals and give you the applications and brochures that you need to get into the program. And really, the program is designed to address recidivism and to get people out of the cycle. And the cycle starts off if you don't have an education, you can't get a job, you can't get a job, you turn to drugs and alcohol, you turn to drugs and alcohol, you eventually commit a crime, you eventually get caught, and you do time. After you do time, you get out and you're back in the cycle. Okay? And so if you're interested in any one of these programs, just let us know. And as I mentioned to you earlier, we have some folks here from Spindletop. We have Deputy Barry and Caitlin. They're going to come and tell you a little bit more about the Spindletop program. And then after they come, we have Johnny, who is with our family services. And he's going to tell you more about the program that they have to offer with it. It's the BIP program, Baddest Intervention and Prevention Program. That's for individuals who have family violence cases. So at this time, we'll have folks from Spindletop.
Thank you. Good morning, ladies and gentlemen. My name is Deputy Patricia Berry, and I am a liaison with Jefferson County Sheriff's Office. I am a deputy employed by the Sheriff's Office, however, I'm a mental health liaison for the county. So I work in conjunction with Spindletop Center. Caitlin is a qualified mental health professional with Spindletop Services, and we work together as a team. And the reason that we're here in the courtroom today is because the judge does care about each and every person that enters this room. And statistics have found that oftentimes people who enter the criminal justice system have mental health needs that are not being met, or possibly substance use issues, or maybe just a lack of resources. So that's what we're here for today, is just to provide you with an avenue for those resources. We're here to talk to you if that's what you choose. If you know somebody, not personally, but somebody else that has maybe mental health issues or substance use issues that are not being addressed, and you feel like they would benefit from those resources, you can also send them our way. Okay, so we have a piece of paper that is on that clipboard at the very front. Whenever you enter the courtroom, you filled out all that paperwork. That is absolutely voluntary. It's not mandated by the court. This Caitlin here is going to tell you how to fill it out. If you choose to do so, we're going to come, whenever they pick up clipboards, we're going to collect those as well. So if you don't want to fill it out, you don't have to, you're not required to. Okay, you can just leave it blank and we'll get back to you. She's going to tell you how to fill it out right now.
At the top of the paper is basic information. It's your name, birthday, phone number, email, address. We need those things to be able to put you in our system and to be able to contact you. Under that is how would you like to be contacted, and the options are call, text, and email. Whatever box you check is how I will contact you. I will not contact you unless you check it on one of those boxes. Underneath that is resources you would like assistance with, and most of those resources is you check the box. I email you either a form you have to fill out to accomplish that resource or a link that you have to do yourself. But if you were to check mental health, which can be depression, anxiety, or PTSD, or substance use, which can be any type of drug or alcohol, then you work with Spinal Talk to get the support and the services that you need for that. Everything else is pretty much self-explanatory. If you'd like to talk to me today about mental health or substance use services, you can write on your paper, please talk to me today, and when the judge calls you up and when he's done with you, I'll come and get you. We'll put you to a back room and we can talk about it, or if you'd rather I call you today, you can write that on your paper, or if it doesn't matter when I call you, you can just check one of the boxes and I'll get to you within the week.
So basically just what we're offering is that, whether it be somebody to talk to, whether it be resources that you didn't know that we had available, or that were available to you. That's what we're here for today, okay? You're also welcome to keep this. It has telephone number on the bottom of it for the Spinal Tap office. This goes directly to our office, our secretary Lance Brown, and it also has a number for the crisis hotline. That hotline is available 24 hours a day, 7 days a week. If you have any questions, we're gonna come by in a little bit and I'm gonna give you some good business cards. You're welcome to ask those questions at that time. All right. And thank you for giving us the time to speak with you. Yes, thank you.
Okay, John?
Thank you, Judge. Good morning. My name is Johnny Stewart and I'm with Family Services of Southeast Texas. You probably know us from our Women's and Children's Shelter. That's for the victims, but we also provide a program, a pre-trial diversion program for if this is your first time found by discharge. We offer a good program which lasts 18 weeks, 2-hour groups, once a week. And we provide you tools and information to help you change those behaviors. Because it's not gonna do any good if you go to jail, you still have those same behaviors, okay? So what we do is we provide a program called the Batteries Intervention and Prevention Program. Like I said, we give you the information and tools that are gonna help you change those behaviors and keep you from coming back to it. Okay? And also it's gonna help you in your relationships. We also have a non-residential treatment, which is free. We have the flyer over there. So that's if you know any victims or you've been victims, we offer free services for that also. Now, big program, you're responsible for that. So take advantage of that so you can change behaviors and you can come back here. Okay? Thank you very much. Appreciate you.
Okay, thank you, Jack.
Thank you, Judge.
Okay,
All of the questions.
okay, now, ladies and gentlemen, we're getting ready to go into recess. And the reason why I'm going to recess is to give you time to fill out the paperwork. And will give us an opportunity to pick that paperwork up from you. We're gonna put you into one of three categories. You'll be in the category of hiring attorney, applying for court appointed attorney. And mind you, that if you apply for court appointed today, your attorney will be appointed today before you leave the court. And if you're in the category of wanting to waive your right to attorney and represent yourself, in your case, you'll have an opportunity to talk to the prosecutor. Y'all able to come to an agreement that will be taken care of. Your case will be disposed of. Okay, before you leave. Now, this is gonna take us a little time to pick the paperwork up from you. And then to go through it, because we have to make sure that it's filled out properly. And, if you need to use the restroom, there are two restrooms right out in the hall. The men's restroom is the nearest restroom, is in front of county court at Law 3, which is right next to it. The women's restroom is on the opposite side of the hall, in front of the 172nd District Court. Okay, now you'll be allowed to go use the restroom. Please do not leave the courthouse. If you leave the courthouse, your name is called, not here in court to answer, then your bond will be forfeited. That means if your bond is forfeited, a warrant will be issued for your arrest. Guess what? You'll be arrested, brought to jail, and then we'll have to go through this whole thing all over again. All right? And so be mindful that we are still in court. So conduct yourself accordingly. If you need help with the paperwork, we have our court personnel who's here, including myself, who will be happy to assist you completing the paperwork. Okay? So at this time, the court will, yes.
If we want to film and let River write, is that what they call pre-trial diversion also?
You can talk to me about that. Yes.
What if you were arrested?
If you wasn't arrested, you wouldn't be here. You would, no. Listen. You might have, in order for you to be here, the jail had to arrest you, and once you arrested, then you get a court date to come here. This is your court of coast here. If you haven't been arrested, you wouldn't have a case here today. You might have been arrested on multiple charges. It's not unusual for people to be arrested for like, for example, I'm driving down the street. Listen, I'm driving down the street and I have a warrant. My back light is out. Right? Police stop me, they arrest me for my back light. They get to the jail, they find out that I have an assault case. I'm just making it up. When I find out, I'm binding out for that assault case, and I'm binding out for maybe the traffic appeal, or maybe I set out my time for the traffic. I don't know. But the point that I'm trying to make to you is, you were arrested. You might not have been aware that at the time that you booked in, that you might have had another case. Okay? Because we have, on our computer, we can go in there, the court coordinator can go in the computer, and they can let you know the date that you were arrested, and then when you got out of jail for this case. And then once you get out of jail, they give you a court date, either to your bondsman, to you, to appear here for your first appearance. You can't come to court, because if you never was arrested, guess what? You must have a warrant out. And if you have a warrant out, guess what? You're gonna get arrested and you're gonna go to jail. Because you gotta go to jail before we get to this point. So if you're on our list, you were arrested, you just wasn't aware. Okay, so at this time, we're going to break. Yes.
You go to the cafeteria? No,
Recess ain't gonna be that, I mean, it's gonna take us a few minutes. I mean, when I say a few minutes, it's gonna take about 30 minutes. Okay, so I mean, if you got time to do that, but you need to make sure you don't leave the courthouse, because once we gonna put everybody in, we're gonna start calling you up before the bench. Okay? Okay, so at this time, we'll be in recess. If you need any help with filling out the paperwork, you can raise your hand, and we have our court personnel, we'll be happy to help you with your paperwork.
Sir, you said about 30 minutes. What time we need to be back in?
No, I'm just saying, right now you gotta turn in your paperwork, and then, because once we get everything, once we go to the police, we don't start rolling, calling people up. I'm just saying, normally it takes about 30 minutes for us to get all the paperwork and go through it, because sometimes the paperwork is not filled out properly.
You said if I talk to the prosecutors, they don't give me a deal, I can say I want an attorney.
Yeah.
Okay.
Yeah, yeah, matter of fact, that's what, there's,
Yes.
this is.
If you leave out of here, you're gonna prolong.
Okay,
You not leave out of here until we make sure everything is correct on that paper. On those papers.
sign that.
Say. You think it's on.
See. You see. Yes, we can. It's boss.
Yeah. Yeah, hold on a minute, I need to, get the.
Go here.
Pull your pants up. Okay, what? I don't need to sit down with it. Gotcha.
But yeah, no. Yeah, you want to talk about it? Huh? Breathe.
Let me,
Breathe.
Yeah, that's what that black robe represented. They all say it. Yeah, great.
Did we go turn in the paperwork?
okay, the person that's on the iPhone on Zoom, please put your mic on mute. Somebody's gonna pick up your paperwork. Mr. Jackson? Jefferson County Court at Law number 2 is back in session. The court is in session. And cause number 25 CCC Aura 0610 case of style. The state of Texas versus Camden Romani Jackson. Mr. Jackson, is that your full name?
Sure.
How are you doing, Mr. Jackson?
Good.
That's good. Now, Mr. Jackson, you represent your case by your attorney Stephen Harris. Attorney Harris, how are you?
I'm doing well.
Okay. Now, the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, thank you.
And Mr. Harris, what is your announcement in Mr. Jackson's case?
Yes, Your Honor. We have a felony case that happened this morning. It's tied to this misdemeanor case. We have entered in a 7-year deferred in that case. It's pending a PSR
Oh,
report.
PSI, okay.
Yes, and that case has been reset in the 252nd to July 29th, 2025.
July 29th.
Yes, Your
Yes, sir.
Honor.
Okay, so we're gonna reset this case to July 29th, 2025. And Ms. Raymond, you can give Mr. Harris his reset. Once you get your reset, Mr. Harris, you're free to go and you have a blessed day. Have a safe trip.
Thank you, Your Honor.
And Mr. Jackson, you can follow the bailiff. You have a blessed day as well.
Thank you, Your Honor.
Okay, you are.
Can anybody hear him or is this just my phone?
Scarlett Cormier or Cormier? This is cause number 25 CCCR 0836. Case is style the state of Texas versus Scarlett Cormier or Cormier. How do you pronounce it?
Either
Okay. Ms. Cormier, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing?
Cold.
Hmm?
Cold.
Little cold? Okay, let's see. If we can get you out of here. Now, Miss Cormier, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line, the title defense?
Yes, sir.
Are these your initials on the line that state you'd like to fly for a court-appointed attorney?
Yes, sir.
And I also have another document. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Okay. Ms. Cormier, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Cormier, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once you get that information, you're free to go.
Okay.
And you have a blessed day. Please have a seat in that
Thank you.
first chair on the wall. Damian McLennan. Mr. McLennan, your full name is Damian Andre McLennan.
Yes, sir.
Mr. McLennan, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. McLennan, you may put your hand down. How are you doing, Mr. McLennan?
I'm fine.
That's good. Mr. McLennan, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to
Yes,
apply
sir.
for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. McLennan, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. McClendon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get that information, you're free to go, and you have a blessed day.
Thank you.
Joseph Lonnie Baker Jr. Okay. Mr. Baker, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that
Yes, sir.
state you like to waive your right to an attorney and will represent yourself?
Right.
I also have another document that is titled waiver of counsel purposes, interview, clear proceeding to trial. You recognize this document?
Yes, sir.
Is this your signature on the line entitled
Yes, sir.
defendant? Now, Mr. Baker, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, have you, talked to Mr. Baker?
Yes, Your Honor. At this time, there is restitution that still needs to be determined whether or not it is in this case. We asked for probably a standard reset to give time to reach out to the victim to determine that before relaying an offer.
Okay, give us a reset date on Mr. Baker. Well, first of all, okay, so y'all need to find out what the restitution is.
If
right?
there is any, yes, Your Honor.
Okay, give us a standard reset,
July the 11th.
July 11th.
Baker. What am I missing?
Just announcement. For 30 days.
Yeah,
For the state to,
yeah,
You need
he
to
pro
register
state, so it'll be an announcement.
okay.
Yeah, okay. This case will be reset to July 11th at 9 a.m. Mr. Baker, on that day, you need to be present in court. You're gonna get your reset from our coordinator. Once you get your reset, you will be free to go.
All right.
And you have a blessed day. Gary Sebastian Joseph. Okay, Mr. Joseph. Your full name is Carrie Sebastian Joseph.
Yes.
How you doing?
Mhm.
Okay, and Mr. Joseph, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Now, Mr. Joseph, I have document before me, two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
That's the one,
Yeah, is this, your signature
for
says,
the point?
I can hand it to him, Your Honor.
Yeah.
is that your signature on the line that's titled
Yes,
Defendant?
sir.
And now there are a set of initials. One set of initials is on a line that states you like to waive your right to an attorney and represent yourself.
Yeah, you want me to crowd that one off? No.
Your Honor, he's wanting to reject the offer and apply for a court appointed. He's
Because
asking.
he had the other one crossed out. He had the court appointed crossed out.
Yeah.
So he needs.
He needs an affidavit, yeah. Let's get at, yeah.
Yeah.
Let's see, just filled out. Is it filled out?
Here we are, Your Honor.
If it's not filled out, he can have
I
a
filled
seat
it out.
at that table.
Yeah.
Did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Broussard, I read your answers. Based on your answers, meet the eligibility requirement for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have the best day. Please have a seat at that chair, the second chair on the wall. Gary Joseph.
I know it look like I'm working. I just confess for the case. I got to go check for a job after I leave. That's what I mean. The dress like for the job you're applying for.
Oh. Now, Mr. Joseph,
Yes, sir.
would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Joseph, you may put your hand down. How are you doing, Mr. Joseph? You doing all right?
Yes, sir.
Okay, now, Mr. Joseph, I have before me two documents. The first document that I'm going to show you is titled Jefferson County Affidavit of Innocence. You recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Judge's Explanation of Rights to Defendants Without Attorney, you recognize this document?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
And is this your signature?
Yes, sir.
Now, Mr. Joseph, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Joseph, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that.
Two.
All right, have a seat in that second chair.
All right.
He wasn't know what we were doing here. Resisting, resisting. Okay. Here you go.
Okay.
The guy, is he still in the back? That might be one. Okay. What's this here? Eric Duncan. That's him now. Yes, Mark, that's the lady who played. She just played, yeah. Justin Jacquet. Yeah. I'm gonna need some copies of this. What's the last one? Miss, right there, you gonna stand right there. We need some copies of that. Okay. This is cause number 25 CCCR 0822, case of style, the state of Texas versus Justin Ross. Is that Jaquette? Mr. Jaquette, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jaquette, would you, you can put your hand down. How are you doing, Mr. Jaquette? Hanging in there? It's like they say, hang on, don't hang up. Now, Mr. Jaquette, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? This document that you signed?
They're saying that I need a court appointed attorney.
Well, yeah, I mean, do you recognize the whole document? That's my question. Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for a court appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? And on page 2 of the same document, there's a signature above the line that's titled Defender Signature. Is this your signature? Now, Mr. Jaquette, before you sign and initial these documents, did you read the document? Did you understand what you read?
Now, the second one, that's representation of for court appointed lawyer.
This is the affidavit. This is, you have your financial information and all that stuff on. I mean, the question to you is, did you read the documents before you signed and initial? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Jaquette, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information, but before you give that, she gives you that information. I don't have a copy yet. I'm gonna read you some bond conditions, and then you'll be able to get a copy of these bond conditions from the coordinator. And it's titled Standard Bond Conditions in County Court Law Number 2, following the return of criminal information in County Court Law Number 2 of Jefferson County, Texas. All bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a drug test when directed to do so by the court, or B, submit to a drug test and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
What's that about?
That's saying that condition number 3 basically says that the defendant shall submit to test for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol, or B, submit to a test for drugs and alcohol, and the test in the case of presence of alcohol in the defendant's body. Okay?
And why is it?
That's your bond conditions. You're out on bond. These are your conditions of release. Okay? Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Please have a seat in that third chair on the wall. I'm gonna need several claps.
Oh, wow.
Where's
We'll just wait till we get you.
Mashana Maxwell? She could come this way.
Oh, she had called me to her, but you called her name. Which person?
Okay, Miss Maxwell. Yeah, your full name is Shayna Maxwell. Ms. Maxwell, would you please raise your right hand? Ms. Maxwell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Maxwell, you may put your hand down. How are you doing, Ms. Maxwell?
I'm doing nothing.
I'm doing fine, thanks for asking. Ms. Maxwell, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Industry. You recognize this document?
Yes, sir.
And is this your signature on page 2 above the line that's titled Defendant Signature?
Yes, sir.
Now, Ms. Maxwell, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Maxwell, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. A court reporter, our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that fourth chair on the wall. Oh, you can go. Yeah, Joe. Dylan Tompkins. Okay, just give a different date.
Okay.
Hold on, man. I'm gonna have to, I'm gonna, you know what? That's the guy I just did. No, we could push it up. We're not gonna push it that far back.
What about before then? Yeah.
There you go. Okay. Let's see, this is Dylan Tompkins.
Your next scheduled court date is July 11th. Your next scheduled court date is July 11th. When your court appointed attorney's contact information is not allowed enough because the company contact. This is it. Yes. Not a problem.
There it is.
Yes.
Oh, brilliant. I'm gonna need that. I'm gonna have, I got a copy of my review. Bond condition. No, I need this on all of this too. Hold on a minute. Let me look at this here one.
Hey.
Okay, I just need that, okay. Mr. Tompkins, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Tompkins, you may put your hand up. No, Mr. Tompkins, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir. If for some reason I can't secure an attorney, can I come back as pro se and represent myself?
Yeah, if you can
by the
change your
court
mind.
date?
You can
Yes.
change your mind.
Okay, yes.
Okay. Now, Mr. Tompkins, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Tompkins, your case is going to be reset to give you a chance to hire your own attorney. But before your case is reset, I need to give you some bond conditions.
Yes, sir.
Okay. Ms. Bailiff, you can hand these bond conditions to Mr. Tompkins once I finish. Here you go. Mr. Tompkins is, bailiff is handing you a document that is titled Standard Bond Conditions in County Court. At law number 2. These bond conditions, I'm going to go over these bond conditions with you. And the bond condition states as follows: defendant, following return of a criminal information in County Court at law number 2, in Jefferson County, Texas, all bail bonds executed for release and the defendant named here shall commit no offense against the laws of this state or any other state or the United States. You understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing drugs and alcohol anytime as directed by the court.
Yes, sir.
The court may revoke the bond and order arrest of any defendant who A, refuses to submit to test drugs and alcohol when directed to do so by the court, or B, submit to testing drugs and alcohol in the test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that
Yes,
condition?
sir.
Now, let's see, I was looking at this thing. Let me see his bond condition back. I don't think there was a threat. I'm gonna take out this part. Okay. Now, do you understand those conditions?
Yes, sir.
Now, if you violate any one of those conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Tompkins, have a seat in that third chair. Wait for your name to be called. Once your name is called, you go to court coordinator, get your reset. Once you get your reset, you're free to go and you have a blessed day.
Thank you, sir.
Okay.
Hopkins?
Mike Watchman, Eric Dillon. We have two people back there. Hold on a minute. Martin Romero. Okay, please come forward. Hmm?
Oh, no, watch the
Huh? Yeah, you were supposed to get some bond conditions.
Yeah, last time was for.
Really? Bill Mosby.
Catch him. The guy that just went out.
I gave him some bond conditions.
Oh, you did?
Yeah, I wrote both of them out.
Oh, okay, but you didn't have his name on here.
Oh, that was,
Judge's explanation, right?
I must have. Hold on a minute. Okay, grab the Jones. His name was Tompkins here, Dylan Tompkins. Here you go. I say, your name is Martin Romero?
Yes, sir.
Okay, Mr. Romero, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Romero?
Good.
That's good. Let me see, DWI. Okay. Mr. Romero, I have before me two documents. The first, let me copy this here. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? What it's costing. I also have another document in his name. I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
And on page 2 of the same document, is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Romero, before you signed and initialed the two documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Romero, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Now, before she gives you that information, I need to go over some bond conditions with you. And the bond condition states that following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds excluded for release of any defendant named herein or orders subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing of drugs and alcohol at any time it's directed by the court. Court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply. Condition number 4 does apply because you have a DWI second, and the DWI second is a charge that is listed as a subsequent offense listed under Section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 states as follows. A defendant whose information charges any subsequent offense listed under Section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir.
And condition number 5, the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition?
Yes, sir.
Now, condition number 6 states that the defendant must attend NA meetings 3 times a week and provide proof to the court. And I'm going to give you a verification form and a list of places in our area that you can attend NA meetings. And with the verification form, you need to, every time that you go to NA meetings, a sponsor will sign it, and you need to bring that form back in court every time that you come to court, okay?
Okay.
So we can verify that you have been attending NA meetings. Do you understand that? All right, now, Mr. Romero, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, please have a seat in the second chair on the wall and wait for your name to be called.
Okay.
Jordan Brantley. Yeah, I think. Did he? I think we gave him a copy.
Yeah.
Okay, Mr. Brantley, your full name is that Jordan I. Brantley? Mr. Brantley, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Brantley, you may put your hand down. How are you doing, Mr. Brantley?
Can't complain, how are you?
I'm doing fine. Thanks for asking, Mr. Brantley. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is that your signature?
Yes.
Mr. Brantley, before you signed and initialed all of these documents that I just showed you, did you read the documents? You understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Sir.
Mr. Brantley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. And I will go over these bond conditions with you. Oh, here you go. Ms. Bosman. Mr. Brantley, the bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions, which in the states following return of accrued information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Mr. Brantley, do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And the next condition does not apply. It's condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by Section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Brantley, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. That's the gentleman that we did him earlier. You Mr. Villa? Yeah. Okay, it's Villa right there.
What is he doing?
He'll get it back to you.
Yeah.
I did not reach you. Had to sit there. Now, Mr. Brantley, you can have a seat in that second chair. Wait for your name to be called. Once your name is called, you be free to go. Eric Duncan.
I'm ready.
Okay, Mr. Duncan. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to? Oh, he has his initials on the wrong line. He has to, he didn't change it. Yes, I have an affidavit before me.
Court appointed, yeah, draw through that one and put your initial on the court appointed one. All right.
Okay, now, there's a set of initials on the line that state you like to apply for court appointed attorney. Did you place your initials on this document?
Yes, sir.
And you also signed that document, is that correct?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And is this your signature on page 2 above the line that's titled defendant's signature?
Yeah, yes, sir.
Mr. Duncan, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Because we already appointed Nathan Reynolds, right? Okay, now, Mr. Duncan, I read your answers. Okay, Mr. Duncan, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will give information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir. You have a good day, sir.
All right, thank you. You have this paperwork? There you go. Michael Washington. Okay, Mr. Washington. Your full name is Michael Washington. Ms. Washington, would you please raise your right hand? Ms. Washington, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Washington, you may put your hand down. I have before me two documents. First document, judge's explanation of rights of the defense by attorney. You recognize this document?
Yes, I do.
Is this your signature on the line entitled defendant?
Yes.
Are these your initials on the line that state you'd like to apply for, that you would like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another device, another document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes, sir.
Right here. Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Washington, you talked to the prosecutors today, is that correct?
Yes.
And there was supposed to be some restitution that is to be made?
Yes.
Okay, and when will you be able to pay that?
I can pay it today.
Okay, once you get Mr. Hold on a minute. Hey, how you doing? Okay, now this is Mr. Andrew Hubel, he's with the district attorney's office. Mr. Hubel, Mr. Washington has indicated that he can pay the restitution today. Now, what is the agreement?
And that the agreement is restitution for dismissal in this case in the amount of $1,000 to Catherine Patterson.
Okay. Okay, so he'll tell you what form it needs to be paid in.
Yeah, in money order or cashier's check, which we talked
Yeah.
about earlier.
Okay, and once it's paid, this case will be dismissed. So, actually, we can release you right now, so you can, if you go get it, he knows where to pay it. He gotta bring it up to us to the DA's
Third
office.
floor, yes.
Money order?
Yeah, money order or cashier's check, either one.
It has to be blank, right?
Yes, so that we can fill in the complaining witness's name.
You understand that?
Yeah, so I put my name on there, $1,000 and just leave it blank and for them to sign it on the third floor.
They're gonna put in the person's name that it goes to.
And they'll generate a receipt for you so that we know that you brought yours in and did your part so that we just.
Okay.
All right,
All right, so you free to go?
thank you.
All right, all right. Louise Villa. This was gonna be a restitution. You can put this in this file. Mr. Villa, your full name is Luis Villa? Is that correct?
Yes, sir.
Mr. Villa, would you please raise your right hand? Mr. Villa, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Villa, you can put your hand down. How are you doing, Mr. Villa? Okay. Okay, Mr. Villa, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
With attorney.
The
Yeah.
thing says
Yeah.
Judge's Explanation of
Yeah.
Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled
Yes, sir.
defendant? Now, are these your initials on the line that state you would like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you
Yes, sir.
recognize this document? On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. Villa, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Villa, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you. And you will be given information to contact him. Our court reporter will give you that information. Once you get that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. And the court will go off record at this time.